name is Bruno and I'm a lawyer in Macau and Portugal and also an arbitrator. And today I would like to talk to you about Macau's new arbitration law, which basically reformed Macau's arbitration framework by unifying both domestic and international arbitration seated in Macau and also implementing the practices and standards under UNCITRAL Model Law. So the main features of Macau's arbitration law is that they apply to both domestic and international arbitration seated in Macau. An emergency arbitrator can be appointed by the parties to resolve urgent matters before an arbitral tribunal is set up. You can obtain the assistance of a court of law to obtain evidence held by one of the parties. Arbitral awards can no longer be appealed to local courts, but the parties can agree that an award can be appealed to another arbitral tribunal. Interim measures issued by a foreign-seated tribunal hold the same legal value as if they were issued by a Macau-seated arbitral tribunal. Arbitration awards involving the civil service, in other words, contracts with the government, must be made public in the government's website. Arbitration awards have the same legal forces as the rulings of a court of first instance. The new law also went over in regards to the recognition and enforcement of arbitral awards issued outside of Macau. And they basically define and determine that foreign arbitral awards may be enforced and recognized in Macau upon request. That request can only be rejected if it is proved that one of the parties suffered from mental incapacity. The arbitration agreement was invalid according to the governing law or the law where the award was issued. There was a lack of notice of the choice or the appointment of an arbitrator, or the award ruled on a matter that is not under the scope of the arbitration agreement. Or finally, the arbitration award is not yet binding, or it was annulled or suspended by the court of the same jurisdiction where it was passed. The recognition of the award infringes public order. Those are the only cases where a Macau court can refuse to recognize and enforce a foreign arbitration award. In Macau, the main arbitration centers are the World Trade Center Arbitration Center and the Macau Lawyers Association Arbitration Center, although ad hoc arbitration is the preferred choice by many of those that seek assistance in expediting decisions on disputes. Macau has entered into several international arrangements regarding arbitration awards. In Macau, it is applicable the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, the Agreement for Reciprocal Recognition and Enforcement of arbitral awards between the mainland and Macau was also entered, and the same agreement was entered between Macau and Hong Kong. The demand for commercial arbitrations is expected to grow because China is encouraging more domestic companies to go abroad and is trying to attract foreign investors into the Greater Bay. In line with this expectation, the Greater Bay Area Arbitration Alliance was launched in 2008 to integrate and support the region's mutual growth by providing accessible, high-quality, cost-efficient dispute resolution services for the development of the Greater Bay Area. It includes the 9 arbitration institutions of the Guangdong Greater Bay Area, together with Macau and Hong Kong arbitration institutions. Macau's new arbitration law is a significant development for the Guangdong, Hong Kong, Macau Greater Bay Area Initiative and intends to provide a robust framework for investors to choose Macau as an arbitration hub to resolve any unforeseen disputes, particularly with investors and operators from the Portuguese-speaking countries. Remember, this article does not represent legal advice and cannot be construed as such. Please contact an attorney to obtain guidance on these matters. Thank you.